Right now, there are gun owners across this country who went to bed law-abiding citizens and woke up potential felons. They didn't do anything different. They didn't buy anything new. They didn't modify a single thing. The government changed the definition around them while they weren't looking. And here's what makes this particularly dangerous. Most of them have no idea it happened. If you own a firearm that falls into any of the categories we're going to break down today, you need to watch this entire video before you touch that gun again. Because the difference between staying out of prison and a federal felony charge right now may come down to something as small as a piece of plastic or a piece of metal that you bought legally, that the ATF approved, and that the ATF has now decided to reclassify. Stay with me. I'm going to walk you through exactly what changed, why it matters, and what you need to do about it. I've spent years working through the legal frameworks around the Second Amendment, federal firearms law, and the regulatory maze that the ATF operates in. What I want to do on this channel is take complex legal developments and give you a clear, honest breakdown so you can protect yourself and your rights. No politics for its own sake, no theater, just the law, what it means, and what it means for you specifically. This one is serious. Let's get into it. Here's the core issue. The ATF, the Bureau of Alcohol, Tobacco, Firearms and Explosives, has a history of reinterpreting existing law without going through Congress. They call it rulemaking. Critics call it something else. But whatever you call it, the legal effect is the same. When the ATF changes how it classifies a firearm, a component, or an accessory, that change doesn't grandfather you in automatically. In many cases, compliance becomes your problem, not theirs. And if you're out of compliance, even unknowingly, you could be looking at a federal felony charge that carries up to 10 years in federal prison. Let me say that again. 10 years, federal prison, for a gun you bought legally. For a part the ATF used to say was fine. This isn't hypothetical, we've seen it happen. And the pattern is always the same. A rule gets changed, gun owners don't find out in time, and the enforcement consequences are real. So what changed this time? The ATF issued a new rule that significantly expands how it defines certain firearms and their components. The specific focus involves configurations and accessories that the agency now says change the classification of a firearm entirely. We're talking about items that were manufactured legally, sold legally through licensed dealers, and in many cases were explicitly not regulated under prior ATF guidance. Now they are, or at least the ATF says they are. And that distinction between what the law says and what the ATF says is where this whole thing gets complicated. Here's the fundamental problem with ATF rulemaking. Congress wrote the laws. The National Firearms Act, the Gun Control Act, those are statutory laws passed by elected officials. But the ATF has the authority to interpret and implement those laws through regulations. When the agency stretches that interpretive authority far enough, you end up with a situation where the agency is effectively writing new law without a vote. Courts have pushed back on this. Some federal courts have struck down ATF rules as overreach. But here's the catch. While a legal challenge works its way through the courts, the rule is still in effect. People are still being prosecuted under it. The legal fight might eventually vindicate you, but that vindication could come after you've already been charged, after you've already spent money on a defense, after your life has already been turned upside down. That's the gap that puts gun owners at risk. The law is contested, but enforcement isn't waiting for the courts to sort it out. Here's where I want to stop and reframe something, because I hear this a lot and it's a dangerous assumption. People say, I bought it legally, I have the receipt, the dealer sold it to me, so I'm fine. That reasoning is understandable. It also will not protect you from a federal indictment. The fact that something was legal when you bought it does not automatically make it legal to possess today if the ATF has reclassified it. Under the National Firearms Act specifically, possession of an unregistered regulated item is the offence. It doesn't matter how you got it. It doesn't matter what the seller told you. It doesn't matter that the ATF itself previously said it was okay. If the item is now classified as a regulated firearm or component and you didn't register it in the NFA registry when registration was open, possessing it could be a federal crime. This is the part that genuinely shocks people, and I understand why. It feels deeply unfair. It should feel unfair because in many respects it is. But fairness is not a legal defense in federal court, and that's exactly why you need to know this before you're sitting across from a federal agent. Let me give you some context here, because this isn't the first time the ATF has done this. Think back to the bump stock ban. Bump stocks were sold legally for years. The ATF itself issued opinion letters saying they were not machine guns under federal law. Then, following the Las Vegas shooting in 2017, the agency reversed course. Bump stocks were reclassified as machine guns. Owners were given a deadline to destroy or surrender them.
No compensation, no grandfather clause in most practical terms, just compliance or felony exposure.
The Supreme Court eventually ruled in Garland v. Cargill that the ATF's bump stock rule exceeded the agency's statutory authority. The rule was struck down. But think about the gun owners who destroyed their legally purchased property to comply, who sold their collections to stay safe, or worse, who were prosecuted before the courts intervened. For them, the legal vindication came too late. That's the pattern, and we're watching it repeat. So here's where we get practical, because I don't want this to just be an exercise in legal outrage. I want you to walk away from this video knowing what to actually do. First, identify whether you own anything that falls within the reclassified categories. That sounds obvious, but the ATF's rule language is technical and often deliberately broad. If you own pistols with certain stabilizing braces, specific short-barreled configurations, or certain accessories that could be interpreted to change the classification of your firearm, you need to look at the current rule language or talk to a lawyer who handles federal firearms law. Don't rely on forums. Don't rely on your dealer's opinion from 3 years ago. Get current, qualified guidance. Second, understand your options. Depending on the rule and the timeline, there may be compliance pathways. In some cases, the ATF has opened registration windows, offered amnesty periods, or allowed for modification or destruction of the affected item. These options are not always available, and they often have hard deadlines. Missing that deadline doesn't get you a warning, it gets you legal exposure. Third, do not talk to federal agents without a lawyer. If an ATF agent contacts you about your firearms, your accessories, or your compliance status, the single most important thing you can do is say, "I'd like to speak with my attorney before answering any questions." That is not obstruction. That is not an admission of anything. That is your constitutional right, and it may be the most important thing you do to protect yourself in that moment. Fourth, watch the courts. Several legal challenges to ATF overreach are currently working through the federal court system. Some have already resulted in injunctions that block enforcement in certain jurisdictions. If you live in a jurisdiction covered by an injunction, that changes your immediate risk picture. But it doesn't change your long-term obligation to comply if the injunction is lifted or if you travel to a different jurisdiction. This is another place where legal counsel matters.
Here's what I want you to take away from the bigger picture, because this is where I think the real conversation starts. A lot of people look at ATF rulemaking and think, this is a government agency doing its job. Regulations happen, adjust and move on. But there's a structural problem that goes beyond any single rule. The ATF has the power to reclassify items, redefine terms, and in doing so, turn ordinary gun owners into felons without any action by Congress. No vote, no public debate in the legislative sense. A rulemaking process that, while technically open for public comment, does not require public approval. The founders designed the Second Amendment as an individual right. The Supreme Court affirmed that in Heller. But the practical exercise of that right is being squeezed, not through outright bans, but through regulatory redefinition, through classification changes, through compliance burdens that fall on the individual gun owner, while the agency faces no consequence for getting it wrong. That's not a Democrat or Republican point. That's a structural concern about how federal power operates against individual rights. And it's something every gun owner in this country should understand clearly. Let me bring this together before we close. The ATF issued a new rule that reclassifies certain firearms, components, or accessories. Items that were legal to own yesterday may now require registration, modification, or surrender. The fact that you purchased something legally does not protect you from prosecution if the ATF has now classified it differently. There are legal challenges underway, but enforcement continues while those challenges proceed. Your practical steps right now are identify whether you're affected,
Understand the compliance options and deadlines, consult a federal firearms attorney if you have any doubt, and never answer federal agent questions without legal counsel present. Here's the bottom line. The ATF does not have to prove you intended to break the law. Federal firearms offenses are often strict liability in practice. That means the only thing that matters is whether you were in possession of a reclassified item after the rule's effective date. Intent, ignorance, and good faith are not magic defenses. The best protection you have right now is information. Know the rule, know your collection, know your options, and know that the legal landscape around this issue is actively shifting, which means staying informed is not optional. It's part of responsible gun ownership in the current environment. If you are unsure whether you're affected, treat that uncertainty like the red flag it is. Get a qualified answer before you need one. The Second Amendment is not self-enforcing. Rights that aren't defended don't hold. And that defense starts with understanding exactly what the government is doing and exactly what your obligations and protections are under the law. If this video helped you understand something you didn't before, hit subscribe. I put out breakdowns like this regularly because the legal landscape around gun rights, self-defense, and federal firearms law moves fast. You need to be ahead of it, not reacting after something has already gone wrong. Stay informed, stay protected, know your rights. And remember this, in a system where ignorance of the law is no excuse, the only rational response is to stop being ignorant of the law.